In Section 4, you will learn about retaliation, preventing harassment, responsibilities of managers and employers, the investigation process, state harassment policies and laws, filing a complaint, and SCOE information.
What is retaliation? Retaliation is any action taken to alter an employee's terms and conditions of employment, such as a demotion or harmful work schedule or location change because that individual engaged in any of the previously mentioned protected activities. Such individuals should expect to be free from any negative actions by supervisors, managers, or the employer motivated by these protected activities. Retaliation can be any such adverse action taken by the employer against the employee that could have the effect of discouraging a reasonable worker from making a complaint about harassment or discrimination. The negative action need not be job-related or occur in the workplace, and may occur after the end of employment, such as an unwarranted negative reference. What is not considered retaliation? A negative employment action is not retaliatory merely because it occurs after the employee engages in protected activity. Also, if employees continue to be subject to all job requirements and disciplinary rules after having engaged in such activity, this is not retaliation. Any employee who has engaged in protected activities is protected by law from being retaliated against because of that protected activity. Protected activities with regard to harassment include making a complaint to a supervisor, manager, or another person designated by your employer to receive complaints about harassment, making a report of suspected harassment, even if you are not the target of the harassment, filing a formal complaint about harassment, opposing discrimination, assisting another employee who is complaining of harassment, providing information during a workplace investigation of harassment, or testifying in connection with a complaint of harassment led with a government agency or in court. Leonard works as a clerk typist for a large employer. He likes to wear jewelry, and his attire frequently includes necklaces and earrings. His boss Joan thinks it's weird that as a man, Leonard wears jewelry and wants to be a clerical worker. She frequently makes sarcastic comments to him about his appearance and refers to him jokingly as her office boy. Leonard, who hopes to develop his career in the area of customer relations, applies for an open promotional position that would involve working in a front desk area where he would interact with the public. Joan informs Leonard that if he wants the job, he had better look more normal, or else wait for a promotion to mailroom supervisor. Is Leonard's boss correct to tell him wearing jewelry is inappropriate for customer service positions? Leonard's jewelry is only an issue because Joan considers it unusual for a man to wear such jewelry. Therefore, her comments to Leonard constitute sex stereotyping. Joan also is suspicious that Leonard is gay, which she says she doesn't mind, but she thinks Leonard is secretive. She starts asking him questions about his private life. Like, are you married? Do you have a partner? Do you have kids? Leonard tries to respond politely no to all her questions, but is becoming annoyed. Joan starts gossiping with Leonard's co-workers about his supposed sexual orientation. Is Leonard the recipient of harassment on the basis of sex and sexual orientation? Leonard is harassed on the basis of sex because he is being harassed for failure to adhere to Joan's sex stereotypes. Leonard is also harassed on the basis of his perceived sexual orientation. It doesn't matter whether or not Leonard is a gay man in order for him to have a claim for sexual orientation harassment. Leonard might also be considered targeted for harassment on the basis of gender identity, which is a form of sex and or disability discrimination prohibited by the human rights law. Leonard should report Joan's conduct, which is clearly a violation of the sexual harassment policy, to a person designated by his employer to receive complaints, for example his employer's designee. Leonard decides that he is not going to get a fair chance at the promotion under these circumstances, and he complains to the employer's designee about Joan's behavior. The designee does an investigation and tells Joan that Leonard's jewelry is not in violation of any workplace rule, that she is to consider him for the position without regard for his gender, and that she must stop making harassing comments, asking Leonard intrusive questions, and gossiping about his personal life. Joan stops her comments, questions, and gossiping, but she then recommends a woman be promoted to the open position. The woman promoted has much less experience than Leonard and lacks his 2-year degree in customer relations from a community college. Has Leonard likely been the target of discrimination on the basis of sex, sexual orientation, or retaliation? We don't know Joan's reason for not recommending Leonard for the promotion, but it is not looking good for Joan. It appears that she is either biased against Leonard for the same reason she harassed him, or she is retaliating because he complained, or both. Leonard should speak further with the employer's designee, and the circumstances of the promotion should be investigated. If it is found that Joan had abused her supervisory authority by failing to fairly consider Leonard for the promotion, she should be subject to disciplinary action. This scenario shows that sometimes more severe action is needed in response to harassment complaints, in order to prevent discrimination in the future.
It is everybody's responsibility to prevent harassment, and it requires everyone's cooperation. A solid harassment prevention program should include a training program that includes objectives, such as learning the definition of sexual harassment, identifying other types of harassment, the legal issues involved in harassment, behaviors that constitute harassment, and what someone should do if they are harassed. It should also include your company's reporting and grievance procedures, as well as information on how to contact the EEOC or applicable state agencies, and what each individual can do to prevent harassment. Harassment thrives in environments with a weak reporting structure, authoritarian management, poor morale, or a chaotic physical environment. Perhaps the single most effective strategy for preventing harassment is for all employees to be on the lookout. When you witness behaviors and language that make other people in the office uncomfortable, be willing to speak up. As a general rule, harassment is not something that just happens. Harassment occurs when each of us, as individuals, fails to take responsibility for the well-being of the people around us. People who consider the behavior of others unwelcome need to take reasonable steps to stop that behavior. Some individuals may find it difficult, under certain circumstances, to speak up. However, everyone needs to take action against harassment at the company. When the behavior is relatively mild, this may mean directly asking the offender to stop, or asking someone in authority, such as the manager or human resource representative, for help. If the behavior is severe, more immediate and assertive action is required. Individuals who deal with the public, or with personnel from other organizations, must always ensure that their own behavior is acceptable. You must report incidents of unwelcome behavior by others in accordance with company policy and procedures. Managers exercise authority on behalf of the employer. This gives them important additional responsibilities regarding unlawful harassment, discrimination, or retaliation. First, all supervisors must exercise their authority to ensure that their workplace is free of any type of illegal harassment, including sexual harassment. They must take every complaint seriously and respond promptly to employees expressing concerns. Second, managers who engage in unwelcome behavior toward others, including subordinates, take a very large personal risk. A court may find them personally liable, in addition to their employer's liability. We can't stop harassment in the workplace unless management knows about the harassment. It is everyone's responsibility. You are encouraged to report harassment to a supervisor or manager or another person designated by your employer to receive complaints as outlined in your company's harassment prevention policy, so the employer can take action. Behavior does not need to be a violation of law in order to be in violation of the policy. Your organization should provide you with a complaint form to report harassment and file complaints, but if you are more comfortable reporting verbally or in another manner, your employer is still required to follow their sexual harassment prevention policy by investigating the claims. If you believe that you have been subjected to sexual harassment, you are encouraged to inform the harasser directly that the conduct is unwelcome and must stop. You should also report harassment to management at an early stage to prevent its escalation. Your organization should have established an effective complaint or grievance process, which includes providing anti-harassment training to managers and employees and taking immediate and appropriate action when an employee complains. Your organization should strive to create an environment in which employees feel free to raise concerns and are confident that those concerns will be addressed. Once you submit your formal complaint or otherwise report harassment, your organization must follow its sexual harassment prevention policy and investigate any claims. You should report any behavior you experience or know about that is inappropriate, as described in this training, without worrying about whether or not if it is unlawful harassment. Individuals who report or experience harassment should cooperate with management, so a full and fair investigation can be conducted, and any necessary corrective action can be taken. Finally, if you are not sure you want to pursue a complaint at the time of the potential harassment, document the incident to ensure it stays fresh in your mind.
Anyone who witnesses or becomes aware of potential instances of harassment should report it to a supervisor, manager, or designee. It can be scary and uncomfortable, but it is important to tell coworkers that it is not okay when you are uncomfortable about harassment happening in front of you. It is unlawful for an employer to retaliate against you for reporting suspected harassment or assisting in any investigation. Anyone who engages in harassment or retaliation will be subject to remedial and/or disciplinary action, up to and including termination. Your organization will investigate all reports of harassment, whether information was reported in verbal or written form. An investigation of any complaint should be commenced immediately and completed as soon as possible. The investigation will be kept confidential to the extent possible. Any employee may be required to cooperate as needed in an investigation of suspected sexual harassment. It is illegal for employees who participate in any investigation to be retaliated against.
Your organization also has a duty to take appropriate steps to ensure that harassment will not occur in the future. Here is how your organization should investigate claims. The designated person or office will conduct an immediate review of the allegations and take any interim actions, as appropriate. Relevant documents, emails, or phone records will be requested, preserved, and obtained. Interviews will be conducted with parties involved and witnesses. Investigation is documented as outlined in the harassment prevention policy. The individual who complained and the individuals accused of harassment are notified of final determination and that appropriate administrative action has been taken. The California Department of Fair Employment and Housing, DFEH, enforces laws that protect you from illegal discrimination and harassment in employment based on your actual or perceived ancestry and age 40 and above, color, disability physical and mental, including HIV and AIDS. Genetic information, gender identity, gender expression, marital status, medical condition, genetic characteristics, cancer, or record or history of cancer, military or veteran status, national origin includes language use and possession of a driver's license issued to persons unable to prove their presence in the United States is authorized under federal law. Race, religion includes religious dress and grooming practices. Sex/gender includes pregnancy, childbirth, breastfeeding, and/or related medical conditions. Sexual orientation. The California Fair Employment and Housing Act prohibits harassment of employees, applicants, unpaid interns, volunteers, and independent contractors by any persons and require employers to take all reasonable steps to prevent harassment. This includes a prohibition against sexual harassment, gender harassment, harassment based on pregnancy, childbirth, breastfeeding, and/or related medical conditions, as well as harassment based on all other characteristics previously listed. Employers are required to provide information to each of their employees on the nature, illegality, and legal remedies that apply to sexual harassment. Employers may either develop their own publications, which must meet standards set forth in California Government Code Section 12950, or use a brochure from the California Department of Fair Employment and Housing. Employers with 50 or more employees and all public entities must provide sexual harassment and abusive conduct prevention training for all supervisors. The California Fair Employment and Housing Act prohibits employers from limiting or prohibiting the use of any language in any workplace unless justified by business necessity. The employer must notify employees of the language restriction and consequences for violation. Also prohibits employers from discriminating against an applicant or employee because they possess a driver's license issued to a person who is unable to prove that their presence in the United States is authorized under federal law. Employers are required to reasonably accommodate an employee, unpaid intern, or job applicant's religious beliefs and practices, including the wearing or carrying of religious clothing, jewelry, or artifacts, and hairstyles, facial hair, or body hair, which are part of an individual's observance of their religious beliefs. Employers must permit job applicants, unpaid interns, volunteers, and employees to file complaints with the California Department of Fair Employment and Housing against an employer, employment agency, or labor union that fails to grant equal employment as required by law. Discrimination against any job applicant, unpaid intern, or employee in hiring, promotions, assignments, termination, or any term, condition, or privilege of employment is prohibited. The California Fair Employment and Housing Act requires employers, employment agencies, and unions to preserve applications, personnel records, and employment referral records for a minimum of 2 years. Employers must provide leaves of up to 4 months to employees disabled because of pregnancy, childbirth, or a related medical condition. And employers must provide reasonable accommodations requested by an employee, on the advice of their healthcare provider, related to their pregnancy, childbirth, or a related medical condition. Employers with 50 or more people must allow eligible employees to take up to 12 weeks leave in a 12-month period for the birth of a child, the placement of a child for adoption or foster care, for an employee's own serious health condition, or to care for a parent, spouse, or child with a serious health condition. The law also requires employers to post a notice informing employees of their family and medical leave rights. Employment agencies are required to serve all applicants equally, refuse discriminatory job orders, and prohibit employers and employment agencies from making discriminatory pre-hiring inquiries or publishing help-wanted advertisements that express a discriminatory hiring preference. The California Fair Employment and Housing Act prohibits unions from discriminating in member admissions or dispatching members to jobs. As well, retaliation against a person who opposes, reports, or assists another person to oppose unlawful discrimination is prohibited. The law provides for remedies for individuals who experience prohibited discrimination or harassment in the workplace. These remedies include front pay, hiring, back pay, promotion, reinstatement, cease and desist orders, expert witness fees, reasonable attorney's fees and costs, punitive damages, and emotional distress damages job applicants, unpaid interns, and employees. If you believe you have experienced discrimination or harassment, you may file a complaint with the California Department of Fair Employment and Housing. Independent contractors and volunteers, if you believe you have been harassed, you may file a complaint with the California Department of Fair Employment and Housing. Complaints must be filed within 1 year of the last act of discrimination or harassment, or for victims who are under the age of 18. Not later than 1 year after the victim's 18th birthday. The California Department of Fair Employment and Housing is committed to providing access to our materials in an alternative format as a reasonable accommodation for people with disabilities when requested. If you have a disability that prevents you from submitting a written pre-complaint form online, by mail, or email, the California Department of Fair Employment and Housing can assist you by transcribing your pre-complaint by phone or, for individuals who are deaf or hard of hearing or have speech disabilities, through the California Relay Service at 711, or call us through your VRS at 800-884-1684. To schedule an appointment, contact the Communications Center at 800-884-1684 voice or via relay operator at 711 or 800-700-2320 for text, telephone, or by email at contact.center@dfeh.ca.gov.
For more information in regards to Stanislaus County Office of Education's board policies and administrative regulations on sexual harassment, please visit our website at www.stancoe.org/division/human resources.
Thank you for your time. Remember, harassment in the workplace is not a new issue, nor, unfortunately, has the presence of it in America's workplaces diminished. In this course you learned what harassment is, how it can occur in the workplace, current legal positions, and how management can maintain a harassment-free workplace. We went over different behaviors that constitute sexual harassment, other types of harassment including abusive conduct, what constitutes a hostile work environment, and how to handle complaints. As we have seen, harassment is pervasive in the American workforce. It is one of the most destructive forces for companies, offenders, and victims. Federal and state courts have both increased their enforcement of harassment laws and seen a dramatic rise in cases over the past 10 years. By following the guidelines laid out in this course, you'll be able to foster a safe, productive workplace. One that's free from harassment of any kind.